We begin our study of evidence admissibility by establishing the baseline, the general rule against hearsay, codified in Federal Rules of Evidence 801 and 802. Hearsay, an out-of-court statement, offered to prove the truth of the matter asserted, is generally inadmissible. However, the law recognizes that certain statements possess inherent trustworthiness, making them admissible despite the hearsay label. This trustworthiness arises not from the declarant testifying under oath, but from the specific circumstances surrounding the statement's creation. This video series focuses exclusively on these exceptions. Specifically, we will examine several key exceptions found under Federal Rule of Evidence 803. These are the exceptions where the declarant's availability to testify in court is entirely irrelevant to admissibility. We will delve deeply into three crucial rules: the excited utterance, the present sense impression, and the statement of state of mind. These foundational exceptions are frequently tested on the bar examination. To fully appreciate the exceptions we are about to study, we must briefly contrast the structure of Federal Rule of Evidence 803 with its counterpart, Federal Rule of Evidence 804. Rule 803 enumerates exceptions where the declarant's availability to testify is entirely irrelevant. These are the exceptions we are focusing on today: the excited utterance, the present sense impression, and the statement of state of mind. Conversely, Rule 804 lists exceptions that only apply if the declarant is unavailable to testify. Think former testimony or dying declarations. For the three exceptions under Rule 803 that we are examining, the analytical focus fundamentally shifts. We are no longer primarily concerned with the declarant's demeanor on the stand, as we would be if they were testifying live. Instead, reliability is guaranteed by the objective circumstances surrounding the statement's creation. This external context, the immediacy, the shock, or the expression of current intent, is what substitutes for the oath and cross-examination. We now turn to the first specific exception under Rule 803 where reliability is guaranteed by external circumstances: the excited utterance, codified in Federal Rule of Evidence 803, subsection 2. The core theory here is that a statement made immediately following a shocking event is inherently trustworthy because the declarant lacks the time or presence of mind to fabricate. For an excited utterance to be admissible, three elements must be satisfied. First, there must have been a startling event or condition that occurred. Think of a sudden car crash or an unexpected explosion. Second, the statement itself must relate to that startling event. It cannot be about an unrelated topic. And third, and perhaps most crucial, the statement must have been made while the declarant was still under the stress of excitement caused by that event. The shock must still be dominating their mental faculties, preventing conscious misrepresentation. The third element, requiring the statement to be made while under stress, hinges critically on the duration of that excitement. The key inquiry is temporal. How quickly did the statement follow the startling event? The law demands that the statement occur so swiftly that the declarant simply had no opportunity to pause, reflect, or fabricate a lie. If the declarant has time to regain their composure, the guarantee of trustworthiness vanishes. Consider a statement made immediately following a severe car collision that is likely admissible. Contrast this with a statement made 30 minutes later, after the declarant has had time to speak with responding police officers or exchange information with other witnesses. By that point, the declarant has had ample opportunity to consciously consider and perhaps misrepresent the facts. The analysis centers entirely on whether the statement was a spontaneous outburst or a considered narrative, focusing strictly on the lack of capacity for conscious misrepresentation. We just analyzed the spontaneity born from trauma in the excited utterance exception. Now, let us pivot to a different kind of spontaneity, the spontaneity born purely from immediate observation. This brings us to Federal Rule of Evidence 803, subsection 1, the present sense impression. The rationale here is that a statement describing an event made while the declarant is perceiving it is inherently reliable because there is no time gap for reflection or fabrication. To qualify as a present sense impression, two elements must be satisfied. First, the statement must be one describing or explaining an event or condition. Second, and critically, the statement must be made while or immediately after the declarant perceived that event or condition. The emphasis here is on near contemporaneous narration. Unlike the excited utterance, which can follow a startling event slightly later, present sense impression demands that the statement capture what is happening now, or what just happened a split second ago, directly reflecting the declarant's current sensory perception. We just established that present sense impression hinges on describing an event while perceiving it, narration simultaneous with observation. Now, let us directly contrast this observational spontaneity with the trauma-induced spontaneity of the excited utterance. The key differentiator lies in the underlying trigger and the resulting temporal window. For present sense impression, the requirement is strict simultaneity. Perception and description must merge. Think of it as narrating a live event as it unfolds. Conversely, the excited utterance requires a startling event, but the statement can follow slightly later, provided the declarant remains under the stress of excitement. The law recognizes that processing shock takes a moment longer than simply describing what you see. Therefore, present sense impression is fundamentally about immediate, objective description of perception. Excited utterance, however, is about the immediate, subjective reaction to trauma. We can visualize this temporal distinction clearly. We have contrasted the spontaneity born of immediate observation, present sense impression, with the spontaneity born of shock, the excited utterance. Now, we pivot entirely from external events to the declarant's internal landscape by introducing the third major exception under Rule 803, the statement of then existing state of mind, codified in Federal Rule of Evidence 803, subsection 3. This exception allows statements reflecting the declarant's current state of mind, emotion, sensation, or physical condition. Think of expressions of intent, future plans, or current mental feelings. For instance, saying, "I intend to leave town tomorrow," is admissible to show intent. However, there is a critical limitation you must memorize for the bar exam. Statements of memory or belief are generally excluded if offered solely to prove the fact remembered or believed. If someone says, "I remember locking the door," that statement cannot be used to prove the door was actually locked. The exception to this exclusion is when the statement of memory or belief is offered to prove the declarant's subsequent intent or plan. Remember, current intent is admissible. Past memory used as proof of fact is generally barred. Now that we understand present sense impression, excited utterance, and state of mind individually, let us synthesize them into a practical decision tree for the bar exam. When analyzing an out-of-court statement, follow these steps sequentially. First, ask, does the statement describe an event or condition while or immediately after the declarant perceived it? If yes, analyze for present sense impression. Second, if the statement followed a sudden, startling event, check if the declarant was still under the stress of excitement when speaking. If so, consider excited utterance. Third, if neither of the above fits, examine the statement's content. Does it express a current feeling, sensation, or, critically, a future plan or intent? If yes, analyze under state of mind. Let us test this rapidly. Imagine a witness shouts, "Look out! That car is running the red light." immediately after seeing it. That is present sense impression. Moments later, after the crash, the witness screams, "I cannot believe he hit us." That is excited utterance. Finally, if the driver had previously told a friend, "I am going to drive across town later today," that expresses intent, falling under state of mind. Master this sequence to tackle these questions efficiently. To conclude our deep dive into these crucial hearsay exceptions, let us anchor our understanding in the underlying rationale that grants them trustworthiness. Present sense impression relies on the immediacy of perception. The statement is contemporaneous with the event. Excited utterance leverages the shock factor, which temporarily overrides the declarant's capacity for fabrication. Finally, state of mind offers direct evidence of the declarant's internal reality, be it emotion or intent. Remember this unifying principle: all three exceptions, present sense impression, excited utterance, and statement of mind, fall squarely under Federal Rule of Evidence 803. This means the availability of the declarant to testify in court is completely irrelevant to admissibility. Mastering these distinctions and recognizing the high trust contexts surrounding these statements is essential. These concepts appear frequently on the uniform bar examination, so internalize these rules now for success later. Well done on completing this section.